as a subcommittee. Today we have 9 items before our special order of business begins at 10:30. 5 of those are on consent. Those are item 3, AB 1563 by Rodriguez. Item 5, AB 1678 by Santiago. Item 6, AB 1906 by Melendez. Item 7, AB 1927 by Lackey. And item 8, AB 2232 by Obernolte. So we can begin today with our first items. Assemblywoman Gonzalez has 2 items. Are you going to start with AB 813?
I sure can.
Okay, great.
Thank you. Thank you, Madam Chair and Senators. Assembly Bill 813 will allow California criminal courts to review challenges of wrongful or constitutionally invalid convictions after sentences have been served. 44 states and the federal government all provide individuals with a way of challenging unjust convictions after criminal custody has ended. However, in California, individuals who gain access to evidence of actual innocence or proof of a defect in the criminal proceeding, including the omission of immigration consequences to a plea deal, have no way to present this before the courts after criminal custody has expired. This omission has a particularly devastating impact on California's immigrant communities. Since 1987, California law has required defense counsel to inform non-citizen defendants about the immigration consequences of convictions. Yet today, we still have some defense attorneys who fail to advise defendants or who fail to understand the consequences of a guilty plea. Many immigrants suffer convictions without having any idea that their criminal record will at some point in the future result in mandatory immigration imprisonment or deportation and will not allow them to apply for immigration status once it becomes available. If passed, 813 will not automatically vacate convictions. It will give people like Sylvia, who we're going to hear from, the ability to present her case in front of a judge. We'll hear today, and at this point I'll turn it over to Sylvia Ocampo, a mother of 3 U.S. citizens who was a victim of ineffective counsel. Go ahead.
Okay. Muy buenos días, senadores. Mi nombre es Silvia Ocampo y vengo de San Diego para compartirles mi historia y pedirles que voten a favor de la propuesta AB 813. Yo llevo 23 años en este país, tengo 3 hijos ciudadanos americanos.
Good morning, Madam Chair. I hope that I can translate as she goes. My name is Sylvia Ocampo, and I came from San Diego today to share my story and to tell you about why I'm in favor of AB 813. I've been living in this country for 22 years, and I have 3 U.S. Citizen children.
Yo pago impuestos y nunca me he metido en problemas de ningún tipo. Trabajo y vivo para mis hijos, sobre todo para la más chica que tiene capacidades diferentes. Hoy desafortunadamente me encuentro luchando contra mi deportación.
I pay my taxes like everyone else. I've never gotten in any trouble of any kind. I live and work for my children, in particular for my younger daughter who has special needs. Today, unfortunately, I find myself facing deportation.
Hace 7 años cometí el error de aceptar renovar mi licencia de manejar sin saberlo. Estaba cometiendo un delito que terminó teniendo grandes consecuencias. Cuando llegué a este país en los años 90, compré un permiso de trabajo de unas personas que me hicieron pensar que eran verdaderos.
7 years ago, I made the mistake of accepting the renewal of my driver's license without knowing that I was committing a crime with grave immigration consequences. When I came to this country in the 90s, I purchased a work permit from some folks that guaranteed me that the permits were real.
Utilicé ese permiso de trabajo para sacar una identificación y eventualmente mi licencia de manejar. Yo renové la licencia de manejar en el 2008. Un año después de renovarla llegaron unas autoridades a decirme que el permiso que usé era falso y que por lo tanto mi licencia había sido obtenida de manera ilegal.
I used the work permit to apply for an ID and eventually a driver's license. I renewed my driver's license in the year 2008. A year later, I was approached by law enforcement who told me the documents I used to get my driver's license were false and that I had obtained it illegally.
Yo no sabía qué estaba pasando y acepté los cargos de perjurio y falsificación de identidad que me estaban atribuyendo, ya que así me dijo que hiciera el abogado que fue asignado a mí. Estuve en la cárcel separada de mis hijos por 13 días. Mi niña solo tenía 40 días de nacida.
I didn't understand what was happening. The lawyer assigned to me told me to accept the charge of perjury and falsifying documents. My daughter, who was only 40 days old at the time, so in order to finish, she did 13 days in jail. So she pled guilty and did 13 days.
Nunca entendí muy bien el tipo de cargos que me dieron y mucho menos lo que podía pasar por haber aceptado tales cargos. Yo lo único que quería era cumplir mi sentencia para regresar a mi familia y trabajo.
I never understood the type of charges that I was attributed, and even worse, I never knew the consequences of accepting them. All I wanted to do was finish my sentence and go back to my family and start working again.
Un año después de haber cumplido mi sentencia, llegó migración a mi casa para decirme que tenía que salir del país por el crimen que había cometido. Mi abogado nunca me dijo que esto podía pasar. Nunca hubiera aceptado los cargos sin luchar.
I thought the nightmare was over, but a year after completing my sentence, ICE came knocking at my door to tell me I had to leave the country due to the crime that I had committed. My lawyer never told me that this could happen. I wouldn't have accepted the charges if I had known.
Ahora me encuentro enfrente de ustedes apoyando una propuesta de ley que nos puede ayudar a personas con casos como el mío.
Now I find myself in front of all you urging to support this bill because I want to help those of us who receive bad counsel like I did.
Quienes recibimos malos consejos de nuestros abogados, cumplimos nuestras sentencias y tiempo después nos dimos cuenta que somos personas deportables. Yo solo pido que se me dé la oportunidad de regresar a la corte con un abogado que entienda mi caso y me pueda guiar de la manera correcta. Les pido por favor que apoyen AB 813. Muchas gracias.
So I want to help those who have received bad counsel, have completed our sentences, and time later we found out that we're now facing deportation. I just want to have the opportunity to be heard in front of a judge and have a lawyer who can guide me through the process. I urge your support of AB 813. Thank you. We'll move on to other supporters. I just want to note that because of the existence of a U.S.-born child with special needs, if it weren't for this, Sylvia would actually have the opportunity to petition to stay here legally. But because of all the consequences that led up to this, and quite frankly, a reminder that this was all because she wanted to work and pay taxes and not rely on any type of public assistance to raise her children, she's now facing deportation and no ability to apply for immigration, a normalized immigration status under most of what we've heard in the United States.
Thank you. Good morning. My name is Rose Kahn, and I appear today on behalf of the Lawyers Committee for Civil Rights of the San Francisco Bay Area, where I founded the Immigrant Post-Conviction Relief Project. For nearly a decade, I have specialized in this field, including co-authoring a book entitled California Post-Conviction Relief for Immigrants. For far too long, I have watched families like Ms. Ocampos's torn apart by convictions that never should have existed in the first place. I've seen the doors of justice closed to my clients who are innocent or whose convictions the U.S. Supreme Court, the California Supreme Court, and this legislative body have all agreed suffer from such a fundamental deficiency that they have no rightful place remaining on a person's record. I've seen people denied jobs, housing, public benefits, imprisoned in jail, and then immigration detention for years only to be deported from the United States on the basis of California convictions that violate the Constitution. People are shocked when I tell them that in this state there's no legal recourse for individuals who are no longer in criminal custody to raise claims of actual innocence or to allege that defense counsel, in dereliction of his or her duties, failed to advise about immigration consequences. Indeed, the vast majority of states and the entire federal court system provide a post-custodial vehicle to challenge these types of cases. The doors of California courts have not always been closed to these claims, and they needn't remain closed. AB 813 responds directly to a 2009 invitation by the California Supreme Court for this legislature to create a new statutory remedy to authorize judges to hear these claims. AB 813 is also the logical enforcement mechanism to follow AB 1343, signed into law just last year, that recognized defense counsel's responsibilities when representing immigrant defendants. AB 813 fills a yawning 7-year gap in California's criminal procedure, ensuring that families will no longer be senselessly, needlessly torn apart as a result of illegal convictions. Thank you.
Good morning, Madam Chair. Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice, the statewide association of criminal defense attorneys. We're very proud to be a co-sponsor of this measure. I'll just say very briefly, really what this bill does is restore what was available under common law in just very narrow circumstances. So this isn't necessarily something new, but it's just something that it's necessary as a result of the court decision. And I'm also available to answer questions. Ask for your support.
Thank you. I'm going to just take a minute to establish the quorum. If clerk would read the roll.
Hancock.
Here.
Anderson. Glazer. Here. Leno. Lou. Here. Lou here. Monning.
Here.
Here. Stone. Here.
Thank you all.
Madam Chair and members, Khalif Osagai on behalf of the California Public Defenders Association, proud co-sponsors of this measure.
Thank you.
Maya Ingram for the ACLU of California, co-sponsor. I've also been asked to convey the support of the Northern California Innocence Project and the California Innocence Project. Thank you.
Thank you. Others in support? Are these speakers in opposition? Yes. You have to make room for them at the table, please.
Sure. Sharon Riley on behalf of the Judicial Council. We are opposed to the bill in its current form, but we have asked for amendments. We've been working with the author's office and the sponsors, and we're hoping that we can work out the questions that we have as the bill moves along. Thank you.
Thank you very much. Others in opposition to the bill? Seeing and hearing none, questions or comments from members of the committee, or is there a motion on the bill? Senator Stone.
Thank you, Madam Chairwoman. Assemblyman Gonzalez, good morning. In reviewing the bill, the accused voluntarily enter a plea of guilty or nolo contendere, and it requires them to sign a form. And California has required judges to inform those who plead guilty or nolo contendere of potential immigration consequences of guilty pleas since 1978, which you recognized. And current law already allows for the sentence or conviction to be vacated if that advisement doesn't occur. So I'm trying to understand the purpose of your bill. We are preempted by federal officials that determine whether somebody should be deported or not deported. If your bill were to become law, it would be probably very challenging for a district attorney to find witnesses for those that wish to change their plea many years after trial. And then also, if the sentence is vacated, can they be retried? So if you could kind of address those issues, I'd appreciate it.
Okay, this is after an individual has actually served their time, so we don't have a process by which after post-conviction, after a plea, which means there wasn't a trial, they pled guilty, that they've served their time and they're out. We have no process in California, unlike 44 states in the federal government, to come back and say, you know, this wasn't explained to me. In reality, even the forms, and I'm working on a different case on this, even the forms that are often given are confusing and in English, quite frankly. So it's interesting that we provide forms about immigration consequences in English to defendants. But this is not just for immigrants. That's one of the reasons I did this. It's also for actual innocence. So if somebody after the fact can come up with information that shows that they were in fact innocent, there is nothing we have in California beyond petitioning the governor to go into a court and have the judge decide if it should be, there should be post-conviction relief. So that's what this does here. And I think that, I don't remember all your questions. I'm sorry. I hope I'm hitting most of them. But this is a situation that we know there are a variety of situations that people find themselves in. Sylvia probably could have taken the case and the prosecutor would have ended up charging something less. She probably wouldn't have been charged with a felony, which really put her in that position. She was encouraged by her defense attorney, and this happens often, like, look, you can do this. All she wanted to do was go back to her kids and work. You can do this. You can serve your time. This will be done, and all fines and everything will be gone. That is a decision she made without, a lot of times the defense counsels don't understand the complexities of our immigration system, quite frankly, and so they're not adequately providing folks who are pleading guilty to these nonviolent crimes with the information necessary to make a decision about what could happen in the future.
But isn't that truly a malpractice case if somebody doesn't provide a defendant with the appropriate ramifications of their crimes? Is this not going to open the doors, the floodgates, if you will, for cases that are many years antiquated and where you have prosecutors that can't even assemble the witnesses to retry the case if they want to retry the case?
It's not a purpose of retrying the case. I don't think the prosecutor would retry the case. I don't think it'll be a floodgate. Sylvia is not looking to charge the defense attorney with malpractice. She's looking to normalize her record so that she can apply for an immigration status that would allow her to stay here with her children, including a young girl who has special needs, allow her to apply for the type of visa, in fact, that she'd be eligible for, but for this conviction. So, you know, I understand your concerns, but I don't think that they're very realistic in the kind of cases that we're dealing with. And quite frankly, you know, a judge would determine whether or not this could even be heard.
And do you see this being a minority of cases that have been heard in California, or do you see this to be a number of cases that are going to be coming back to the courts for codification?
I don't have the numbers for that, and we really don't know. We tend to find these things out when somebody has a lot of these folks, unfortunately, have already been deported. Sylvia has the benefit of having some support systems that have allowed her to understand that although there's no remedy right now, that perhaps in the future we could create a remedy. But we just don't know, obviously, and it takes resources and ability to even go back to court and do this. But it should be an option for those who, after the fact, have nothing else to do. And also, I don't want to get too hung up. I mean, I very much wanted to do this bill because of Sylvia's case, but she lives in my district. She's worked very hard as a hotel worker for many years, and her story was very compelling to me. But it's also folks that actually have evidence of actual innocence. There's nothing in California that allows you, after you serve your time, to petition the court and have that reviewed, vacated.
Thank you.
Thank you. Senator Monning.
Thank you, Madam Chair. I want to thank the author for bringing this forward. Quisiera decir gracias por su presencia, señora, y por su servicio al Estado y a su familia. Muchas gracias por su presencia. My question for the author, this doesn't create an automatic right. It creates a right to be heard. It's still within the discretion of the court to determine whether the appellant, whether the previously convicted defendant would be eligible for this relief. Is that correct?
Absolutely correct.
Thank you, Madam Chair. I'd like to move the bill at the appropriate time.
Thank you. It's the appropriate time, I think. The motion is to pass to rules, which I believe is going to re-refer it to appropriations. But I also thank the author for bringing this forward, and Sylvia for the courage to come and present with you. I've noticed over my years in the legislature, sometimes it's one case in our district that leads to law that benefits the entire state of California. So it's, I think this is a good step forward, and pleased to support the bill. Would you like to close?
I just respectfully ask for an aye vote. Thank you.
Hancock?
Aye.
Hancock, aye. Anderson? No. Anderson, no. Glazer?
Aye.
Glazer, aye. Leno? Lou? Aye. Lou, aye. Monning?
Aye.
Monning, aye. Stone?
No.
Stone, no.
Okay, and your second bill, AB 898.
AB 898 will add a murdered firefighter's former fire department employer to the list that the Board of Parole hearings notifies when the inmate convicted of murder seeks parole. The fire department must register with the Board of Parole hearings to receive the notification and provide appropriate contact information. According to the California Department of Justice, 37,128 arson crimes were reported from 2010 to 2014 in California. Arson isn't a victimless crime since it has a potential to take the lives of people, including the firefighters responding to the arson. The notification requirement proposed by AB 898 will provide the opportunity for the fire department to reflect on the actions of the individual seeking parole. A similar law is already in place for the former employer of a murdered peace officer. It's time that we extend this notification to the men and women who serve our communities as firefighters. I respectfully ask for your aye vote.
Witnesses in support.
Good morning, Madam Chair, members of the committee. Christy Valma on behalf of the California Professional Firefighters. We appreciate the committee's consideration to offer parity to fire departments. As our author stated, it's opt-in by the fire departments to receive the notification. Firefighters live and work as a family and a team. They mourn their fallen decades after they've left them. And in the case of a murder, the injury is so much more dramatic, and the desire for supporting the family remains. And so we urge your support today.
Thank you.
Madam Chair, members, Randy Perry there and Reed and Associates on behalf of the California Department of Forestry firefighters and PORAC in support of the bill.
Thank you. Others in support.
Dylan Gibbons with the California Special Districts Association in support.
Stacia Boatner on behalf of the California State Association of Counties in support.
Thank you. Others in support? Are there speakers in opposition to the bill? No?
Late support. Dan Filizato on behalf of the Los Angeles County District Attorney's Office in support.
Okay, thank you. Speakers in opposition? Seeing and hearing none, are...
I'm prepared to move the bill when you're ready.
Thank you, Senator Anderson. Senator Stone.
Thank you, Madam Chairwoman. I want to compliment Assemblywoman Gonzalez for bringing this forward. It's eye-opening to understand that there's 37,000 cases of arson in such a short period of time in the state of California. I remember a horrific incident called the Esperanza Fire in Riverside County. You may remember it was arbitrarily set when we had a Santa Ana wind in Riverside County that killed 5 U.S. firefighters. The gentleman was convicted to life imprisonment, and certainly if he attempts to make any parole requests, it's very important that the firefighter families are notified and hopefully to keep this horrible individual behind bars for the rest of his life. So I applaud you for bringing this forward. I'm happy to support it.
Thank you. Is there a motion on the bill? Oh, it was. Thank you, Senator Anderson. Looks like a good bill. Would you like to close?
Ask for your aye vote.
Thank you. Please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson.
Aye.
Anderson, aye. Glazer. Aye. Glazer, aye. Leno. Lou. Aye. Lou, aye. Monning.
Aye.
Monning, aye. Stone.
Aye.
Stone, aye.
Yeah. We will hold the roll open.
Remove the consent.
Oh, Senator Liu has just moved the consent calendar. Thank you. Why don't you read the roll?
Hancock.
Aye.
Hancock, aye. Anderson.
Aye.
Anderson, aye. Glazer. Aye. Glazer, aye. Leno. Lou. Lou, aye. Monning.
Aye.
Monning, aye. Stone. Stone, aye.
Okay, that has enough to pass. We'll hold the roll open for the absent member. Number 4, Assemblyman Stone, AB 1597. Welcome to the committee.
Thank you, Madam Chair and Senators. Under existing law, sheriffs in local jurisdictions are allowed to put together programs that their inmates can go to with the hope of reducing recidivism, getting the education they need, programs that help them get on with their lives, and in exchange for that, a slight reduction in their sentence. What this bill does would allow those sheriffs, if they want to put a program together, to apply those same principles to the pretrial population. Those folks who are there in the local jails, but have yet to be convicted. The benefit then is if they take programs that we know reduce recidivism, take pressures off of those jails in the future, then that's to their benefit should they ever be convicted. If they're not convicted, they've had the opportunity to continue with some anger management, classes towards their GED, other kinds of programs that benefit them once they do get out, again, reducing the possibility of recidivism and helping that community stay stronger. This bill has very broad support, as you'll notice, and with that, I ask for an aye vote.
Good morning, Madam Chair and Senators. Lieutenant Wayne Billowit on behalf of Los Angeles County Sheriff's Department. We feel this is a very important next step. We have been using these milestone credits on the sentence population and have seen better outcomes both out of custody and in custody, as these are used for GEDs and other type of academic achievements. So we urge your support for this bill, and thank you.
Others in support?
Madam Chair, member Sean Rundle with the California Peace Officers Association in support.
Madam Chair, the members, Paul Yoder on behalf of Mayor Ed Lee and the City and County of San Francisco in support of the bill. Thank you.
Donna Seitz, representing the Los Angeles County Board of Supervisors in support.
Stanisha Boatner on behalf of the California State Association of Counties in support.
Asha Harris on behalf of the California State Sheriff's Association in support.
Dennis Cuevas Romero on behalf of the California Attorneys for Criminal Justice in support.
Thank you. Are there speakers in opposition? Oh, I think we have late.
Yes, very tardy. Khalif Osagai, California Public Defenders Association, also in support.
Thank you. Are there speakers in opposition to the bill? Seeing and hearing none, Senator Monning.
Thank you, Madam Chair. I want to thank the author for bringing this forward. Just quick question for you or your witness. So a pre-conviction inmate who might voluntarily opt for consideration for one of these programs, would there be any possibility of prosecution using the inmate's efforts to enroll in the program in a prosecution suggesting that it's some type of evidence of guilt?
No, that would not be allowable as evidence when that individual does go to trial.
Thank you very much. Thank you, Madam Chair. With that, I'm willing to move the bill.
Thank you. The bill's been moved. I want to thank you and also the Los Angeles Sheriff's Association for bringing it forward. It's a common sense measure, probably long overdue, and I think will lead to safer communities. Assemblyman, I would appreciate being added as a co-author as the bill moves forward.
Thank you, Madam Chair. We're happy to.
It's a really good bill. So please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson? Is he here? Glazer? Oh, Anderson. Anderson, aye. Glazer? Aye. Glazer, aye. Leno? Liu? Aye. Liu, aye. Monning?
Aye.
Monning, aye. Stone? No. Stone, no.
Okay. Thank you very much. We'll hold the roll open again for the absent members. Put that bill. Assembly Member Baker is our last item.